Hey, everybody. Welcome to our podcast. An attorney and an accountant walk into a bar. I'm the attorney. I'm John, and my buddy here.
I'm Kent, and I'm the accountant.
All right. What are we going to talk about today, Kent?
Oh, cockamamie laws in the great state of California.
Yeah, there's some good ones on that.
Yeah, let's get into it.
Let's get into it. So, Kent, I came across a new case that I found fascinating. You can read about it actually in the Wall Street Journal, and Daily Journal. A lot of places. It's pretty commonly reported on cases at work. So, there's a company, Gilead, and they were recently approved for a new HIV drug.
Okay.
And this HIV drug apparently has some side effects. So apparently there's some kidney problems you can get from it and some bone problems you can get from it. And, you know, that's not unusual for drugs, and I'm sure it's better than having AIDS, right? So
Ostensibly, sure.
yeah. So basically, this company then started trying to innovate a new version of the drug that had less side effects and less problems. And then they got sued. Apparently a mass tort claim, or what we call a class action. I'm sure everyone's heard of those. And so there's 24,000 patients who are suing for damages because they didn't bring the innovation on soon enough. So they didn't bring it to market quickly enough in their minds. So they're being accused essentially of slow walking the innovation, and they're being accused of having the motive that, well, they slow walked it so they could make more money on the first version of the drug before they rolled out the second version of the drug, right? And the company was like, no, wait a minute, you know, we've got to do all this testing. There's all these barriers. We don't know how quickly we can make it. We don't know how expensive it's going to be. And apparently the lower court said, well, yeah, you know, once you start trying to innovate,
You must.
once you start, you better finish. You better get it done, and you better get it done fast enough, which is really interesting because it seems very speculative to me.
That's mind-blowing, because what if they just weren't able to come up with a new formulation, and they just were like, listen, it's too dangerous for the population, we can't come up with it? Could they then be sued to say, hey, you're in charge of making a better drug than you did before? Well, how dare you not come up with a better version?
That's what the lower court said, and apparently the appellate court, which is a 3-judge panel, as you may be aware, and the judges, of course, as one might expect, were Governor Brown and Governor Newsom appointees. So anyway, yeah, that's basically what they said. So,
John, have you ever watched the movie Minority Report with Tom Cruise?
oh yeah, absolutely.
It gives me Minority Report vibes, where they, for those that haven't watched it, they use psychics or telepaths to arrest people for crimes that they were going to commit in the future, in the present.
Yeah.
So they arrest them in the present for a crime they have yet to commit.
Yeah.
Put that against this case, and we're talking about drug companies, and extrapolate that against other industries too, right? In the law, where you can now extrapolate and say, well, I think we'd mentioned before, car companies, if they fail to come up with a safer version of this vehicle, why shouldn't they get sued?
Well, there's a lot of talk about that, and of course the objection you hear to is, oh, come on, you know, this is just about big pharma. This is just about the big evil drug companies, and you know, the ruling was probably limited to drug companies. Well, it doesn't work like that, and the reason it doesn't work like that is this is the court making a new law, and when the court makes a new law, it's very different than when a legislative body or an executive body makes a new law. So when the legislature, let's say the legislature wanted to make it a class actionable thing for a drug company to fail to innovate a new drug, you can do that.
Sure.
You know, it might be a lot of argument whether you want to do that or whether that's commercially practical, but you can do that.
Okay.
And when they do make that law, as you will see in some of the other things we'll talk about in this podcast, is there's an effective date. It's usually something like January 1st, 2024, the new law goes into effect. I'm sure we've all heard that, right? Well, when judges make new laws.
When they become legislators.
They don't make new laws. They can't make new laws. So what they do is they interpret the law to mean something different. That's how they make new laws. And when the judges interpret a law to mean something different, they mean, oh, it's always been that way. We're just discovering what it really meant to be. So judicial new laws, since they're not new laws, are retroactive.
I mean, there's some function in society with that. For example, like witch hunts should be outlawed. Going back infinitum, so anyone that's currently going on witch hunts, that should be illegal.
Currently, right?
Yeah.
Okay. So let's say it's always been legal to do witch hunts.
Sure.
And then at some point, somebody says, well, you know what? Turns out, second thought, maybe witch hunts weren't such a great idea. You know, science isn't too good on who's a witch and who's not a witch. And
right.
This is getting misused in a lot of ways. Okay, so let's not do witch hunts anymore. What you can't do is punish the people who did witch hunts in the past, because it used to be okay.
That's true.
So if it was legal to do a witch hunt pre-2024, you can't sue people or punish people or especially put people in jail for doing a witch hunt, even though maybe they should have been. You can't.
Sure.
Different when the judge does it. Because when a judge says, oh, you know, witch hunts were always bad.
Sure.
We just didn't know it, or we just hadn't interpreted it that way before. Well, you can go back and get those people now.
Now, I have a question about jurisdiction. So this company, Gilead, if they weren't California-based, and they sell this product in California, would it have the same impact? If we're talking about jurisdiction between states and federal, is there an issue with that? Or if let's say they were based in Utah,
well,
or some other state?
This is a state tort.
Sure.
So the fact of the matter is, if you do business in California, that gives you minimum contacts equaling personal jurisdiction. So you have automatic jurisdiction over any company that does business in the state of California, regardless of where they're domiciled.
Got it.
So we could talk for an hour about jurisdiction. So there's two types of jurisdiction: subject matter jurisdiction, which is jurisdiction over the topic.
Yeah.
So, for instance, in federal jurisdiction, you have bankruptcies exclusively federal. You can't have state bankruptcies. Admiralties exclusively federal. Patent, trademark. Those are subject matter jurisdictions. And then you have personal jurisdiction. Do I have jurisdiction over the company or the individual? And so, for instance, can a California court do something to a Texas resident? Well, the answer is yes, if the Texas residence has minimum contacts sufficient enough to give rise to personal jurisdiction. And doing business in a state, well, that just does it. So
Got it.
you
Yeah,
have
okay.
jurisdiction over the company. And then, then the question becomes, well, is it something exclusively federal? Well, no, it's not. Tort law just plain isn't. So, yeah, these guys could get sued in any state
Sure.
for, whatever it is they did. Now, you're not going to be able to have, for instance, like Nevada residents suing on this theory if it's only a California law, because the Nevada residents have no nexus to California, and then there's conflict of laws.
So
you're going to drive me crazy with that one.
Outside of the
So the short answer is yes.
Okay. So outside of the complication of law, we really talk about the underlying principle behind innovation, and basically the what we can interpret as the disincentivizing folks from actually making innovation, or those that do having any customers or commercial relation to the state of California.
Yeah, I mean, that's certainly one way, and you do see a lot of companies that just won't do business in California. Certainly, if you look at firearms manufacturers, people who sell firearms parts and accessories, you'll just see, actually, I would say the majority have, specific statements on their advertising. We don't do business in California. We're not going to ship to California. If you've got anything to do with California, don't even go on our website. We don't want you.
I see.
Very, very explicit. So yeah, you're already seeing that sort of thing. But I think, again, getting back to the point is, okay, so number one, it's really problematic when judges make new laws like this, because they're retroactive, essentially, because of the fact that they're interpreting existing law. They're not supposed to make new law. The other big problem with it is, if you wrote, again, a piece of legislation that said, well, drug companies, once they start innovating, they have to make reasonable efforts, or however you want to write that law. Again, whether or not that law should be, well, that's what you have debates about.
So
the big difference when a judge does it is other judges are going to take that precedent and they're going to apply it to new industries and new fact patterns and new circumstances, because that's what precedence is.
But isn't this why we see a lot of times in the news, the Supreme Court refuses to even hear a topic? Because one of the things they do, I've heard, is they kick it back and they say, that's a legislative issue. We're not going to listen to this or preside upon it because we're not going to create law. The Supreme Court. I've seen some inkling on that.
Sort of. I mean, it doesn't really work that way, because if it gets to the Supreme Court, it's already in the judicial system. Usually when the Supreme Court passes on a topic, it's not because they're saying that's an issue for the legislature, because that's usually not, it wouldn't usually get to the Supreme Court at that point. Usually when the Supreme Court passes on a topic is, one, there's not sufficient conflict among the circuits and they feel it's settled law and it doesn't need to be addressed.
Sure.
Or two, it's a political hot potato and they just don't want to deal with it. I mean, that happens a lot where they're just like, yeah, no, we're not doing that one yet, just because they don't want the trouble, as it were.
Sure.
So, and there's a lot of other reasons the Supreme Court will pass on stuff. And, the Supreme Court's selective because there's only so much they can do. There's only one body, and they want to focus on things that I think are important, or they feel are important or specific to a particular topic. But again, the issue comes because it's precedent, right? Because and that's the lower court's job, is to take the rulings from a high and try and meld them into something that applies to other things. I guarantee you this is going to get applied way beyond drug companies.
Yeah.
And it's hard to imagine where it might go.
We know we're already extrapolating on some of the bigger contexts. We talk about big food, automakers, firearms manufacturers, things throughout our society that affect our day-to-day infrastructure, right? Farmers, for example, right? How they innovate, how they bring our food to the table, or their treatment of animals, and the fact that they didn't innovate enough to create a safer, non-GMO alternative to X.
Yeah, I think if you can prove that is causing injury to people, it's possible. How about failure to innovate sweeteners that don't cause metabolic disease? How about, all sorts of failures to innovate? And if the motive is to, sell out a particular product or take a particular product line out to its maximum profit before you introduce a new product line, well, that's what they're basically saying. Will it be a tort for an automobile manufacturer to fail to innovate an autopilot system that would avoid collisions? Maybe. Why not? I'm sure they're trying to do it, right?
In the drug case, though, there's probably a way to create enough of, we'll call it, detriment to a population. Meaning, if someone says, hey, version 2 of the new Ford didn't come out in time, how many people are potentially hurt by that? But in this case, people are physically injured. In other extrapolations, there's higher risks of cancer. There's, a very specific medical detriment. Now, I understand the drug industry is very tricky. And we all remember the old commercials that have gone on at Remnant Time, where they show this wonderful couple and they're advertising for some drug, but the last 30 seconds of the commercial is someone speed reading through all the potential side effects. And you're like, oh yeah, this drug is for sleepiness, but the potential side effects are liver disease, diarrhea, death, anything else, any number of things they seem to just list.
Side effects may include pain, sore throat, infection, gas, and constipation.
Other serious stomach conditions may still exist.
I like the one that says may cause suicidal thoughts. It's like, wow, that's kind of rough.
And usually those are for happy drugs,
Exactly.
right? This is an upper, but you may
want to kill yourself.
You may want to kill yourself.
You might want to.
Yeah.
You might think about it. Anyway.
You might.
Yeah. So that's a big problem for sure.
So you're saying that these
But I think
disclaimers don't work?
Well, no. Okay. Well, I mean, I think though your point was, well, maybe we should have this, requirement of drug companies because of the harm. Is great. And I think that is what the court was thinking for sure. The problem is that is not the court's job. It just isn't their job. So what you see here is legislatures not doing their jobs.
Yeah.
Why? Well, I would submit to you that perhaps the drug lobby is pretty powerful and they'd probably shut down anything like that. So now the judges are stepping in and doing the job. Well, good, it seems, right? Why not? Well, the reason why not is because the consequences to business are go far beyond what the courts can imagine, simply because a legislature could write a law that was just about pharmaceutical companies. And only pharmaceutical companies had to make these innovations. And only pharmaceutical companies could be sued if they failed to do so. Could they do that? Of course they can do that. And they can say it's effective on January 1st, 2024. The problem is when the judges make the law, it can't be limited to pharmaceutical companies because what they're saying is there's actually a tort. And torts can be committed by anyone.
Sure.
TACSIS could be sued for failure to innovate a new tax saving system that we were working on, and then our clients got paid too many taxes. I know it sounds far-fetched, but why not?
So the fear in our eyes, or at least my eyes, for society is the extrapolation in and of itself, that what this means. Because I'm far from being empathetic to big pharma. I've watched enough documentaries, and we talk about the current pharmaceutical gold rush for Ozempic, right? For example, where they're out there and it's going to be this $1 trillion giant of revenue
Mark
stream.
my words, it will be.
And so what people see in society, what we see anecdotally, at least on my end, is that there's this push for this magic drug solution for society, only to find out later on the impact against a very large population is detrimental, and the drug companies' potential sway over things that may be more sensible than use of this drug. Now, I'm not saying this applies to a virus like HIV, very specific, very targeted, but the same principle, I think, is applicable to large drug companies and how they treat the population and their goal for pushing
I agree with you 100%. I think that big pharma is intentionally or unintentionally evil. I think that they cause more harm than good, honestly. And if that's all this was about, I would say, raw court. Good job. You got them. But that's the problem is, and the problem that we don't see. Because if you read this, you might go, drug companies, F the drug companies.
Yeah.
I agree. But the law creates a new tort. They could go anywhere. And the unintended consequences, I think, are going to be staggering. We'll see. I mean, it's going to happen.
So we live in a state that is on the vanguard, not necessarily in positive light, of establishing new laws.
That's a great point, and that's what led me to this. So we looked at this Gilead case, and I think we've talked it out. But it made me think of something. What should we be telling our clients and our listeners about the crazy new laws in California? Maybe some aren't so crazy, but I think they're worth talking about, especially as it applies to employers and especially as it applies to landlords. And then there's also a couple of kind of politically fun ones in here too. So, there's a minimum wage increase. Well, that's pretty boring. That's only 50 cents. Who cares, right? But how about this one? Paid sick leave. That's something that our clients better know about. You got 40 hours or 5 days of accrued sick leave and paid time off basically every year. And you better be giving that to your employees or you're going to end up with some PAGA claims, and you don't want one of those. But if you get one, give me a call.
Well, just to be clear, it's up from 2. So the state mandatory was 2, correct? Right. And then so you're adding 3 days.
Yeah.
And what a lot of listeners may not know is that PTO, or paid time off, as it's commonly called, is not a mandatory benefit for employers to provide to their employees.
No, it's not. And I think paid off is a really, really interesting topic. One of the uses that I've seen that I think our clients and our listeners should know about, especially if they're business, is how PTO can be used to actually reduce the amount of paid time off that your employees receive. It's like, whoa, how do you do that? Well, how about this one? Give your employees unlimited paid time off.
That seems counterintuitive.
That seems counterintuitive.
Yeah.
That's crazy talk, right? They'll never come to work.
Yeah.
Well, sure, they'll come to work, because if they don't do their job and complete the tasks that they're given, they could be terminated. Now, this is not going to apply to your fast food worker or your blue collar worker, but it certainly applies to people in our industry. It certainly applies to lawyers and accountants, programmers, people who work in white collar jobs, where again, we're talking about exempt employees, salaried employees, and giving them unlimited paid time off. And you might ask me,
is it industry specific?
Is it industry specific? That's a good point. But I think more importantly, the employer can actually use such a policy to reduce their employment costs.
You're talking about the accrual and the need or the requirement to pay off any accrued time off for employees that are separated from the company.
Right. Or yeah, I mean, and it carries on the books as a liability too, right? So here's a good one. Number one, statistically proven that employers who give unlimited time off, actually employees take less time off. Isn't that weird? And the way the employer can control it is, number one, making it so that any time off has to be approved by a supervisor. So now the employer has control over really how much time off the employee gets. Mm-hmm. And two, having very specific performance goals. So, you know what, employee, you could take all the time off you want as long as you get this list of work done, and you give the employee enough work that, well, maybe they're not going to get too much time off in order to get their work done. So, one, you can actually reduce the amount of time that's taken, and two, you can avoid having to pay out, which can be a huge amount of money, for employees who don't take and who accrue time off and then accrue this liability that when they do terminate, that you have a huge check to write.
I think the application of that, though, has positive effects dependent on industry. So I hear of, and I see a lot of that in tech industry, especially in California, where a lot of the work is remote, or a lot of the work, even pre-COVID, was remote. And the nature of the work, whether it's in development or R&D, we notoriously hear about Google's campuses and how opulent we in our field we think of it as opulent, having just free meals and bikes and cars available for all their employees. And part of that is to create or encourage creativity. And part of potentially unlimited time off allows folks to go on a hiatus to develop the next Google Maps or the next ChatGPT, and understanding that time off creates separation and creativity. Now, industries like ours, which are more, we'll call it rote and not as dynamic from a usage standpoint, is that we are we're wearing suits and actual collared shirts. And when we show up, the idea of having a month-long plus secondment doesn't really work, because there are legal statutes or court dates involved. In our case, there are very specific and immovable timings from filing requirements with the IRS and other bodies that we report to. And so those things create rigidity in the nature of our work that are not compatible with unlimited time off.
But you could still give it to your employees.
You sure can. Sure can. And you're talking about the manipulation or the potential, we'll call it arbitrage.
I think it can be arbitraged. I think it can be manipulated, and I don't think it's always to the advantage of the employee.
That's true.
Is my point. Here's a good one. You're going to love this one. This is the last little employment law one. So we have Senate Bill 700, which make it unlawful for an employer to discriminate against a person in hiring and termination or any term or condition of employment. And that is unlawful to discriminate for the use of cannabis.
So apropos in the state of California. First, we were one of the leaders in medical use marijuana, right?
Which, of course, got
use.
abused like crazy.
Absolutely. And then we went to recreational. So now it's a no hold barred. There's a lot of both licensed and unlicensed cannabis stores in every city across all the counties.
Here's a statistic for you. Did you know that the illegal sale of cannabis has actually increased since it was legalized?
Well, I have thoughts on that in terms of cost for legalization. When you make it so onerous to comply,
and so heavily taxed,
it's a disincentivized
to be legal.
To be legal, so it's disincentivized to be legal. Yeah. So. To our earlier conversation with the drug company, disincentivized to innovate. Right. That seems like a running theme.
True enough. But my concern for employers is, I haven't seen this statute yet, but I really hope there's some limitations on this. I would hope that, for instance, heavy equipment operators or airline pilots or, people whose attention to their job could actually cost someone their life.
Sure.
Or, a limb in some places. Certainly, I hope that, and I'm sure there is some limitations on that. But that being said, but the big fear with this one is not, I think, that, I won't be able to terminate that pot smoker. Well, you're going to be able to terminate him because you just have to find some other reason to terminate him. Because if they're like
performance,
because if they're really stoned out of their mind, they're probably not doing a good job. But here's my fear, and I'm going to share an anecdote with you from a business that I operated some years ago. And that was when they first had medical marijuana and everyone was out there, go see Dr. Feelgood. He's going to give you a card. Just tell him, your back hurts, and he'll give it to you. And it costs you, $50. And everyone went and got their medical marijuana card, and everyone went to the dispensary and bought their pot, right?
Sure.
Well, all of a sudden, I had employees, not a few, quite a few, come into work stoned out of their minds. Mm-hmm. I would get on the elevator with them at 8 o'clock in the morning. I'm like, this guy smells like weed. What the heck?
Yeah.
And their eyes were red, and there were performance problems. And I wasn't really in a position where I could just, off with their heads because there were people I needed.
Yeah.
So what I did is I actually had an employee-wide meeting. I came in with a bottle of liquor. And I put it down on the table and said, I'm going to start drinking this. 8 o'clock in the morning, every day I'm just going to be drunk out of my mind, and I'm going to run this company like a ship onto the shoal. We're just going to run this company right into the ground because your CEO is drunk out of his goddamn mind.
Now, is there a sense of responsibility, though, from the top down? Like you're saying that your leadership, no one wants to follow or be a part of an organization where top leadership has such disregard for their organization that they will come in intoxicated and inebriated. Are you saying that that's we'll call it the trickle-down effect?
Well, my point was this. Would you want me to be your CEO? Would you want me to be your leader? And the answer is no. And the answer is why? Because it's inappropriate and counterproductive to be using drugs or alcohol at work. So I don't care what you do when you go home.
Yeah.
But I do care that you come to work stoned, and it's not acceptable any more than it would be acceptable for me to be drunk.
So let me caveat with, I don't disagree with that sentiment. But you and I are in positions of management or leadership in organizations. But I do remember the days when I was just a cog in the wheel. And in those days where you're like, that's great. Leadership has responsibility, but they're held to a higher standard. If an individual is a cog in the wheel, and that goes that goes for the sentiment of the folks that go, thank God it's Friday, and oh shucks, it's coming to be Monday. Those folks that dread the work week and feel that their job or position on a day-to-day basis, it doesn't have meaning or purpose, then they view the importance of what they do with what you would think is disregard. So them being high, and in some cases, maybe the old attribute is hungover, right? But not necessarily actively drunk. I get that. But it's because they don't find that the work they do has purpose. They're not purposeful in what they do. So why would they care, John?
Well, you're right. And those people should be fired. I don't want them.
And that is the job
But
of
getting
management.
back to my point,
Yeah.
is my fear for employers, and it's just a warning, is this law is going to going to create the attitude in some employees that you can't screw with me for smoking pot, so I'm going to blow pot smoke in your face. And I think that's just going to happen. And, employers have to be aware of that.
Sure.
And, don't get all hot and angry because someone's smoking pot. Find some other damn reason to fire them.
I would say, as a tactical advice, is say nothing. Talk to a good employment attorney.
Yeah, come talk to me.
Yeah.
So anyway, what's another one? I think another one I think is important to hit is we've got some really interesting landlord-tenant laws. Some ones I'm sure our landlords don't know about, and I will be sending out a memo to them about this. Big one: security deposits.
That's AB 12.
AB 12. That's a good one. Yeah. So, number one, landlords are no longer going to collect more than 1 month's rent, regardless of whether the unit's furnished, as security deposit. And if no more than and landlords also will now have to return a security deposit after the tenant makes a certain number of on-time payments. I think it's 8 or 10. I forget the exact number. So basically, you'll be able to take a security deposit, but it can only be 1 month rent, so no more first, last, and security. And you'll also have to give the security deposit back after they've paid a certain amount of rent on
We had
time.
the discussion earlier in our podcast about retroactive items that are either legislated or done by the court. Because this was legislated, the landlords that have security deposits for existing tenants, because the 2 times rent hasn't changed since 1977. And in that time frame, do current landlords have to give back? Are they subject to this same rule?
Oh, I was hoping you weren't going to ask me that because I didn't quite look at it all the way. I know this, though. I will research this further. There's a lot of text in this law, and a lot of it has to do with when the lease was signed, and there is some retroactive stuff about giving the rent back or the security deposit back. So they can't penalize you for having accepted or having required a security deposit in excess of this, but I do believe there are some quasi-retroactive parts of the law where after a certain performance period, you might have to give some of those security deposits back.
And so what I've read, and I was cursory on this review because it affects, we deal with a lot of landlords in our practice, and they usually don't fall under an exemption. So one of the exemptions I read was about, we call it small landlords, and the specific caveat is folks that have no more than 2 properties but under 4 total units, and that's really, we'll call it the real mom and pop shop, which I don't know the extent of that because there's other places I'd love to explore about, does an ADU count? And if it does, how is that under the small landlord exemption, and a few other extrapolations. But I love to know, outside of calling gloom and doom, what can a landlord or owner do to help mitigate the fact that they're going to get a security deposit, which typically is to give them some sort of security when there's damage on their property. But
or they don't pay rent.
Or someone doesn't pay rent.
Yeah. Well, I would tell you, Kent, that the answer is to get a credit report to make sure that your client's creditworthy. But you can't do that anymore either.
Well, you can't get a credit
What?
report?
Crazy new law. You cannot use the client's credit report as criteria in deciding whether or not to rent them a property. You can only require that they prove that they have adequate income. That's all.
I heard, and I don't know if this is currently in law, but I heard that you can't also use criminal history as a deciding factor.
That's been that way for a while, but you always had the credit report one, which is a big one. And here's the problem with that one. So one of the ways that landlords could protect themselves is determining whether a tenant had been evicted before,
Sure.
or there had been unlawful detainer action required, or maybe many. And the problem is there are serial tenants out there who
Sure.
will rent a property, maybe pay a couple months rent, stop paying rent, and then it takes
6 months.
I got one we're working on now that we're 5 months into it because they have all these tricks they can pull and the court system's backed up and, there was COVID, this and that. So there's tenants actually out there that haven't paid for years.
Wow.
So, the downside of that for the tenant was, when they go get a new place, there's going to be an unlawful detainer and that'll be on their credit and then we'll be able to rent a bicycle. Not so anymore.
Wow, it's clean slates all around.
Clean slates all around.
Holy smokes. It's just, if there's ever an advertisement to move to California to become enter the rental game, this is it, right? Just we're talking about
Come to California, be a scumbag, don't pay your rent.
We talk
It's
about
perfectly fine.
disincentivizing certain things, but incentivizing other things. Yeah. Have you ever heard of owner-operator beneficiary bonds? So it's sort of like an insurance, the idea of bonding around things. I think that's going to be potentially relevant going forward because landlord owners need to have some level of security. And now I don't know who bears that cost, but buying some level of insurance that usually goes towards unpaid utilities, repairs, legal fees, even pet fees I've heard on that. And then, but there's also the old school way, right, that you and I kind of chit-chat about, where landlords and tenants, if you pick the right tenants, have good communication, be proactive on fixing things that are broken during their tenancy, and then knowing that tenants are technically still liable for damage. So I just want to say to tenants that just because you don't have a security deposit doesn't mean you can punch holes in all the walls and walk away. There's still some culpability on that.
Good luck suing most of those people, though, because they don't have anything. So let's wrap it up, Kent, with maybe a couple of fun ones.
Sure.
Not really sure how this was, but Senate Bill 14 classifies child sex trafficking as a serious felony. It wasn't before?
Oh, my God. Wait.
I sure as hell thought it was before, but okay. Just so for all you child sex traffickers out there, watch out. Yeah. Here's another one. This is a good one. So AB 360 prohibits coroners, medical examiners, and physicians from using the controversial term excited delirium as a cause of death and from being recognized as a valid diagnosis.
So what
the hell's excited delirium?
What exactly is excited delirium?
I have no idea. I've never heard of it.
That sounds like a really cool band name, though.
That's a good one.
If there isn't one already.
Delirium. Da, da, da.
If there's a band out there, Excited Delirium, send us in some snippets. I'd love to hear what that sounds like.
I absolutely would. So that's a weird one. But, it's kind of disturbing about that. I mean, it's kind of funny, excited delirium. It sounds like, what was it? They used to say that women had like nervous breakdown or something. Mm-hmm. We don't know what that was. What's the legislature doing telling doctors what is and what isn't the medical condition? That's kind of nutty.
Well, I'll take the other take. Just hearing that, I don't know how I would classify excited delirium.
I don't know. I feel like I'm in excited delirium right now because I'm having a really good time doing this podcast. So, I'm just going to leave this one. And this is one of those ones I think we just put it out there, and I'm not going to say a damn thing about it.
What is it?
AB 1084. Department stores with at least 500 employees in California are required to have gender-neutral toy sections. I have no idea, but there you go. Anything else? Okay.
Is it okay to say that our state is living up to an old adage? I didn't grow up in California, but I always heard of it in the Midwest. We call this the land of fruits and nuts. And so I think it's living up.
I said we weren't going to comment on it, Ken. Damn it.
Well, it's not just about that. It's about every single legislation that we've been discussing
and apparently,
tonight.
SB 407 says that if you're Catholic or a Christian, you're not going to be able to adopt people.
Wow.
Because that one says that the Department of Social Services is directed to ensure that LGBTQ youth are placed with supportive and gender-affirming foster parents. All right, so, that's a good one, Bill. But you know what? These were laws passed by the legislature.
Yeah.
And they have an effective date, and we know exactly what it says and what it's limited to. And I think that's the point of the whole podcast about crazy laws is, at least when the legislature does it,
That's true.
you know who did it.
There's
And you
some
know what it
parameters around
says, and you know what the parameters are.
Yeah. Well, I think that's all the time we have for tonight.
I think it is.
All right. Thank you for joining us. Thank you for listening to the podcast. We'd love to hear from everyone. If you have something to add or say to us, we'd love to hear from you. If any crazy new laws that you've heard of that we didn't cover tonight, we'd
Yeah,
love
if you
to
want
hear
us to
about
talk about a crazy new law that affects you, I think we should take that up.
Yeah. So please like, subscribe. Thank you so much for listening. You can reach us at podcast@taxis.com. You can also go to taxis.com/podcast to see all the other episodes. All right. I'll talk to you soon. Thank you. Talk to you soon.
Peace out.
Deuces. Okay.